Klingerman is also going to be assisting on the case, as well as Kirsten Valenzuela. However, they are unable to be here today.
All right. Thank you.
Good afternoon, Your Honor. Simbo Dole on behalf of Governor Hobbs, and here with me is my colleague Noah Gabrielson.
Good afternoon, Your Honor. Alexander Samuels here on behalf of Director Thornell. With me and behind me is my colleague Josh Bendor.
Good afternoon, Your Honor. Emily Skinner. I'm advisory counsel for Aaron Gunches, the real party in interest, and he is present by telephone from the Department of Corrections.
Do we have Mr. Gunches on the line?
Yes, I can hear you, Your Honor.
Can you hear us?
Yes.
Okay.
Your Honor, excuse me, I should also advise the court that Ms. Price is listening in on Teams. Thank you.
Anybody else on Court Connect that we haven't recognized that's on the line remotely? All right. I believe this hearing is also being live streamed, so at least it should be being live streamed. That was the intent. It will be live streamed. All right. Anybody think there's somebody else that we're expecting to be here that's not, that I just don't know about, that we should be waiting for, or are we good to proceed?
I think we're good to proceed, Your Honor. I was just asking co-counsel whether or not Brittany Kay was going to be joining, and when we spoke with her earlier, I think it's unlikely that she will be able to join us.
For the record, she is on Court Connect.
Oh, she
She
is?
is?
She
Okay,
is on
well, thank you.
In his live stream?
We are live streaming.
We are live streaming? Okay, so, anyone else have any thoughts, preliminary matters before we get started? On people that we would expect to be here, attorneys or otherwise, that we're waiting on? No, we're good. All right, then we'll go ahead and get started. I've received a notice of Arizona Supreme Court order, which I've read, including the order from the Supreme Court of Arizona filed by Mr. Samuels. And I've seen the response to notice of Arizona Supreme Court order filed by Mr. Klingerman. So let's assume that Mr. Klingerman is right and that this is not moot. Ms. Clace, Mr. Green, what can this court, the Superior Court, do about it, even if you're right about everything? What remedy can this court fashion? What can this court do, given the current status of the warrant and this court's understanding that it expires? And someone tell me if I'm wrong, I've read it. Looks like the latest it could expire would be 11:59 p.m. tomorrow night.
Yes. Your Honor, so there's several potential remedies. I mean, first of all, what we're asking for is the opportunity to present the information to show and prove our contention that the Arizona Department of Corrections Reentry and Rehabilitation were not meeting their obligations to faithfully execute the laws, and in so doing, they were violating victims' rights. Now, as far as the remedies that we would be asking for, or that this court would have at its disposal, some of that, well, a lot of it is going to depend upon the factual findings of the court in the event of an evidentiary hearing. One possibility would be to order the governor, and I'm going to say Department of Corrections just because I'm so used to calling it that over the years, to order the governor and the Department of Corrections to prepare for the execution when and if the warrant issues. Also, we could seek in order to preclude and enjoin the governor against directing the Arizona Department of Corrections to no longer or to stop preparing for an execution, as our contention they have an obligation to do as part of their obligation to faithfully execute the laws. We could also, again, another enjoinder or injunctive relief would be that the governor as well as the Department of Corrections are enjoined from refusing to carry out an execution when all the conditions precedent are met and it is possible to do so. Also, the victims would be asking for a form of declaratory relief as well. So there are a number of potential remedies and relief that we would be seeking.
No offense, Mr. Green, but I heard a lot of whens and ifs. I have an order that's gonna expire. Either it is expired or it's expiring by the end of tomorrow night at the latest as I read the order. 24 hours from a time that was never set from today. And was a time ever set for today, or was it just today and then 24 hours after the Department of Corrections set a time?
It was actually set today, Your Honor, in a filing with the Arizona Supreme Court. Typically what would happen is that 20 days beforehand, before the execution date, the director would designate an hour. We filed something pursuant to that rule saying that we were not designating an hour of execution, but that to the extent the director needed to identify a 24-hour period during which the warrant was active, that 24-hour period was the 24 hours of today. And so the warrant expires at 11:59 p.m. tonight.
Do you disagree with that, Mr.
No,
Vice or Mr. Green?
I'm sorry, no, we recognize the reality of the warrant, that is the current warrant that is expiring. We understand that. What we're saying is that there is still a cognizable constitutional right of the victims that needs to be vindicated, and there are forms of relief. Exactly what those forms take will depend upon what the factual findings are. Whether or not another execution date gets set will depend upon what those findings are.
Ms. Clace, did you have anything to add on that point, or are you gonna be talking to, or is it just going through Mr. Green? I don't
Oh,
want.
no, I'm sorry, we would probably be both of us.
Yeah, I don't have anything to add. I agree with Mr. Green's comments.
So, here's why I ask, let's assume you're right, let's assume it's justiciable, let's assume it's an actual controversy, let's assume it's right, all those, whatever you wanna call it, not when and ifs, okay? But I have an expiring order that if it expires, ARS 13759 provides the Supreme Court shall issue a warrant of execution, not this court. The Supreme Court shall grant subsequent warrants of execution on motion by the state, not this court. So if I have an expired order, or warrant, excuse me, an expired warrant of execution, what remedy can I fashion, and what controversy is there for me to resolve when there is no then warrant in place? I don't want to litigate a case that's on what and ifs. I think I'm only supposed to litigate cases that are on here and nows. So what? I guess I'm trying to articulate as best I can. I mean, there's cases that identify what justiciable is, what actual controversy means, what ripeness means, but I don't think I'm supposed to litigate things that are on what and ifs. I'm supposed to do things that are in dispute.
Yes. I think when the Attorney General's office, back in, I believe it was January, moved to withdraw their request for the warrant, I believe, and they can correct me if I'm wrong, that one of the rationale behind it is the inability to carry out an execution. And then that, again, was asserted later in the flurry of litigation that occurred at the Supreme Court level. If, in fact, that is not true, or there are facts that essentially dispute that, which we say there is a dispute, in fact, so does the Arizona Supreme Court, that then would lay the groundwork for us seeking that the laws be faithfully executed. In other words, we're here because a warrant was issued by the Arizona Supreme Court, and we certainly don't dispute what 13759 says about the warrant process. But the fact is that the Arizona Supreme Court issued a warrant of execution, and then the next day, the governor said, I'm not gonna do it. It's not gonna happen. And then, of course, our contention is that in doing so, violates the law. It violates the principle and the law that the governor faithfully execute the laws. It constitutes an illegal reprieve, a reprieve that's being granted without a recommendation of the Board of Executive Clemency. And in doing so, it also causes more delay. In causing more delay, that violates the victim's constitutional rights to prompt and final conclusion. So those are the injuries. That is the controversy, an ongoing as well as prospective injury. I'm sorry, Judge.
I was going to say, how do I tell them, you need to prepare for a death penalty for which I don't have a warrant?
Well, we are not saying that right now, it will depend upon factual findings, what relief this court fashions. The relief may not be ordering them to prepare for an execution immediately, but it may include ordering them to get prepared in the event of a warrant. It may be simply ordering the governor's office to cease directing the Department of Corrections to not prepare. So there are a number of different forms of relief. There is still this cognizable, ongoing injury to the victims. Now, I'd also point out that if we are to say that, well, the warrant expired, clock ran out, nothing to do here, everybody go home. Well, then what we have is a situation where, by virtue of the executive branch, the governor, the Department of Corrections, not carrying out their duties, they have created an unreviewable legal issue. And one of the things that we cited in our response to the notice this morning is that even though the warrant is expiring, I think the case law, the Thompson case, that talks about if a matter is of great public concern and it threatens to evade judicial review, that is another reason to proceed forward. I would also point out that the Arizona Supreme Court is clearly aware of what is happening, what it is that the victims are asking for. So as far as what should happen, should there be, for example, an evidentiary hearing, instead of taking my argument for it, I was going to read into the record from the decision order, not yesterday's, but the one dated March 22nd in Hobbs v. Price. And the paragraph that I'm reading from is towards the end, and it says, the issues raised by the parties and amici regarding the executive branch's obligation to take care that the laws are faithfully executed, to grant reprieves, commutation, and pardons after convictions upon such conditions and with such restrictions and limitations as may be provided by law, and to protect victims' rights to justice and due process, and this is the important part, present mixed questions of law and fact that are not properly before us. And then it refers to specifically the declaration of Director Ryan Thornell that was filed by the respondents, and then the declaration of Frank Strada that was filed by the petitioner. Now, the language that says mixed questions of law and fact that are not properly before us being, of course, the Arizona Supreme Court, I think our contention is as lawyers, that signals, well, where is it proper? Clearly, issues of fact are resolved here at the trial level. So here we are. Oh, and Judge, and I know this was in our notice, but of course, yesterday's order contained the language that despite the fact that the Arizona Supreme Court denied the extension of the warrant, they said that it was, and I want to make sure I have the language correct, it was without prejudice, well, it was basically without prejudice to the proceedings in the trial court. I'm not sure if you have that language in front of you. So again, we have a recognition and an acknowledgement by the Arizona Supreme Court that, at least impliedly, there is a justiciable issue that should go forward. There are factual disputes that do need to be resolved here. Exactly what happens after this court makes a decision on what relief is appropriate, then I think we all know and expect that there would be additional litigation. Oh, and I'm sorry, and the Supreme Court did have a copy of the complaint, the petition for special action that we filed here. Thank you, Judge.
Ms. Tice, anything?
Nothing to add, Your Honor, thank you.
Or who wants to speak for the defense, or the defendants first?
Your Honor, I'll speak first. I think we'll both have something to say, but I'll speak first. I think they've simply failed to articulate anything that this court can do. I mean, the question that started this from Your Honor is what the court can do at this point, and I think the answer is nothing. They've talked about various things, but the reality is if you look at their complaint, what they were seeking was an execution on a particular date. And the director and the governor are without any legal power to conduct an execution without a pending warrant of execution, and there will be no pending warrant of execution as of tonight. The idea that they would need some sort of fact finding in front of this court in order to, I think, fully articulate some other claim, that's not how this works. The claim that they've presented to this court is that there should be an execution, and it's simply moot once the warrant goes away tonight. You heard from their side, we are here because a warrant issued. They said that. It's undoubtedly true that that's what set all this off. It's important to note that as of midnight tonight, this case is no different than any other case. There are other death row inmates whose appeals have been exhausted, who do not have pending warrants of execution. This case looks exactly like those cases after midnight tonight. This one is no different, and we are right back to square one. Just like those other cases, it doesn't mean another warrant of execution won't be sought at some point, and that certain issues could become right. But as to the point that this will keep repeating without being able to be reviewed, it's worth noting what an exceptional set of circumstances this was in this particular context of this particular warrant. It was initially sought by Attorney General Brnovich. Since then, there was a change of administration not only at the Attorney General's office and the Governor's office, but perhaps most importantly at the department, where the director's position turned over, other key positions turned over, the Assistant Director of Operations position, which is a key centerpiece in the execution protocol. There was no one in it when the warrant was issued, and we were in a fundamentally different position than when the warrant was first sought in December. That's not the type of thing that's going to keep repeating itself. And it's worth noting how it would have to happen for there to be another warrant. The Attorney General is the only person that can seek a warrant. The state must seek a warrant, a subsequent warrant, which any warrant at this point would be, in the Arizona Supreme Court. The Attorney General represents the state in the Arizona Supreme Court. And she has said that she will not be seeking warrants unless and until the department is ready. And so the only way there's going to be another warrant here is if the Attorney General seeks one, and the only way the Attorney General is going to seek one is if the department is ready. And so the facts and circumstances that have played out over the last few months will not be repeating at all. Any future warrant of execution, the facts and circumstances will look entirely different. And this litigation, this type of litigation would likely be entirely unnecessary. But even if somehow something like this was necessary, it would look very different. And so to have this court try to resolve this dispute after the warrant has expired on sort of hypothetical facts and hypothetical things about what might happen if and when any other thing happens, it just doesn't make sense, and that's not what this court is here to do. The Arizona Supreme Court did say yesterday that their order was without prejudice to anything that might happen in this court, and of course, that this is a separate proceeding. That was in a criminal case about the warrant. It would have been, I think, pretty odd for the Arizona Supreme Court to dismiss this complaint in a separate criminal case. It does not mean they resolved any questions about justiciability or anything like that. What they did is they left it open for this court to decide. And as this court has flagged at the beginning of this hearing, there are real questions about whether there is any type of justiciability or anything like that here. But even if you make a lot of assumptions about this complaint, it's simply moot once the warrant expires. If I could have one moment.
But even if it's not moot, let's assume it's not. Let's say it fits into the exception they cited, something of great public interest that capable of repetition. Let's just say, or let's say hypothetically they're correct that there is some constitutional injury, and say what they allege is true. What can I do about it? That's where I'm stuck. I mean, what can I do? Because there's no warrant of execution to do anything with. I don't know anyone's position. There's no one seeking anything, and there's no one on record opposing anything. So it's kind of like, what can this court do about it? Because I can't remedy it. Like, I can't undo a plea if victims' rights are violated. I can't undo a sentencing that was imposed. I can't throw something off a ballot. I can't tell the Supreme Court, I can't stay their order, I can't extend their order, I can't issue a warrant. I mean, that's where I'm really stuck on this, that even if there is something justiciable, in my mind, until there's another warrant, there's nothing at issue for me to decide. So that's why I keep asking this question, because even if, moot or not moot, what can I do?
I agree, Your Honor. I mean, look, we're stuck on a lot of other things, including justiciability and all the rest, but you're right, you can make a lot of assumptions, and you still get to that fundamental question about what this court could order, especially on what they've asked for in this complaint. You look at the prayers for relief in this particular complaint, they say things that aren't true anymore once the warrant has expired. They say that it is currently possible for the director to carry out a lawful execution. He can't after midnight tonight. They say
there. How could he do it today when there wasn't compliance with the 35, 24, all those?
He could not. To be clear, he could not. My point was simply that once the warrant has expired, that is clear in a different way, but it's clear either way. And so I agree with Your Honor. I don't have an answer to that question. I haven't heard one from the other side, either on the papers or in court today. And with that, I think I will turn it over to Ms. Dool.
Ms. Dool.
Thank you, Your Honor. While there's been lots of briefing and filings over the last several months on the issue of Mr. Gunches' execution, this is the first time we've appeared in person on these weighty matters since Governor Hobbs has taken office, and especially with Ms. Price and Ms. Kay on the line. I'd like to take a moment, Your Honor, if I may, to convey to Ms. Price, Ms. Kay, and their families on behalf of Governor Hobbs and the director our sincere condolences for the unspeakable loss that they've suffered and the pain that we know they continue to live with. We see them, we feel for them, and we feel for every Arizonan who's a victim of a crime. But in our system of justice, the state prosecutes crimes not just for individual victims, but on behalf of the people as a whole. And so too, Your Honor, must the executive fulfill its solemn duty to carry out criminal sentences. And when it comes to carrying out the most grave of sentences and the most awesome and irreversible of the state's power, the death penalty, the law, the state constitution commits to the governor, to the executive, to the department, the authority and discretion to ensure that it can do so lawfully, effectively, and as humanely as possible. And the law commits to the executive the authority and the discretion to balance that duty with other constitutional duties. So while we empathize with the plaintiffs here, what they seek is an unprecedented encroachment on the executive branch's authorities, duties, and discretion. I want to, Mr. Samuels addressed most of Your Honor's concerns very well, and the governor agrees with the arguments made on behalf of the director. But I want to address very quickly counsel's reference to the without prejudice line in the Supreme Court's ruling. As Mr. Samuels alluded to, that line, counsel is trying to make it do a lot more than it can possibly do. That line just explicitly states what is obvious, that the Supreme Court can't make any determination as to the special action filing in this case. But this court, you, Your Honor, you can do that. And in fact, you must do that. This court must apply and abide by the Supreme Court's recent rulings. On March 22nd, the Supreme Court ruled that even with a valid death warrant, there's no legal duty on the executive branch to carry out an execution on a date certain or on plaintiff's demanded timeline. And after yesterday's Supreme Court ruling, the argument that there's any legal duty is even more baseless because the warrant has expired, as Your Honor has correctly noted, as the critical factor here. So not only is there no duty, but the governor and the director are in fact without any legal authority to do what the plaintiffs ask. So in short, Your Honor, the plaintiffs cannot escape the unavoidable legal implications of yesterday's Supreme Court ruling, of the Supreme Court's March 22nd ruling, and of the expiration of the warrant. The governor believes the case was baseless in any event, but as plaintiff's special action complaint all but concedes, plaintiffs have no case at all absent a valid death warrant. And as to Your Honor's question, what can this court do that you keep asking again and again, the answer is truly nothing. The only thing this court can do under the facts and the law before us right now is to issue an advisory opinion, and the court should not do that.
Ms. Gelling, did you have anything?
I'm simply advisory counsel for Mr. Gunches, so.
Mr. Gunches, did you have anything to add as a real party in interest?
I guess not, no. Doesn't seem like there's anything to add.
All right. Back to Mr. Green and Ms. Clace, last word for.
I think I'll let Ms. Clace begin.
All right.
Your Honor, just a clarification as to the plaintiff's demanded timeline. The victims didn't demand the timeline. This was a warrant filed by the AG's office in December, and it's the Arizona Supreme Court who set the timeline under Arizona law. But as far as what the victims can seek and what can be done after this court makes findings of facts and settles the factual dispute, victims have a right under ARS 1344-36A, that's the re-examined statute that states the failure to comply with the victim's constitutional or statutory right is a ground for a victim to request a re-examination. So they may not, obviously this court can't issue a new warrant for execution, but that statute should be enough to allow the victims to seek a remedy, again, in the Arizona Supreme Court. If the factual dispute is settled and ADCRR could indeed have carried out an execution, that is a clear violation of the victim's constitutional rights to a prompt and final conclusion of this case after the conviction and sentence, and it's a violation of their right to justice, which is also enshrined in Arizona's Constitution, and it, quite frankly, would violate their rights to be treated with fairness, respect, and dignity.
When you talk about the right to re-examination, that hearing you said in the Supreme Court, not in this court.
Your Honor, I don't read any of the victims' rights statutes to be specific only to the Superior Court, but in the criminal code there is a provision that allows victims to seek a re-examination when there has been a clear a violation of either a constitutional or a statutory right, and that's ARS 1344-36A, but also under ARS 1344-37A, they have standing to seek an order, whether it's from a superior court or an appellate court.
I'm sorry if I wasn't clear with my question. I'm sorry about that. So I get the right to the re-examination. You had mentioned the Supreme Court. I was wondering, were you saying that the right for re-examination hearing would be here as part of this proceeding? Or are you talking about a different proceeding in front of the Supreme Court? Or are you saying the right to re-examination is the remedy that I keep asking?
Yes, I'm not suggesting that this court would conduct a re-examination hearing, but there is a statute that potentially provides victims another remedy, another mechanism to enforce their rights.
But again, assuming it was a re-examination or anything, what could this court do though? You know, this isn't like victims' rights weren't complied with and a plea went forward, sentencing went forward, and you want the court to undo its own, you know, doings that didn't honor victims' rights. Or a case I heard about, or it was a parole or something, and victims' rights weren't complied with, so they had to go back and redo that hearing because victims' rights weren't complied with. Those really aren't all fours with this kind of situation, and that's where I'm just kind of really stuck about, you know, if I go to all this effort at the end of the day and hear all this and decide all these facts on what ifs, and you know, I think it's like an advisory opinion, as the governor's attorney just pointed out. It's like I'm giving an advisory. Should this come back before the court? Should there be another warrant? Here's my advisory opinion of what should happen. I don't necessarily disagree that there might be something justiciable here, either based on the exception Mr. Green cited, or the fact that if there truly is a constitutional injury, it has to be redressed. The problem is, what can this court, and how can this court, or can this court even redress this certain kind of alleged injury, given the procedural nature of this warrant? So it hasn't expired yet, so I guess I have to wait for it to expire before I can say it's truly not something I can address, but that's tomorrow. I'm not in a position to be able to have that finding of legal mixed question of law and fact today, let alone tomorrow. So that's where I'm just really stuck, though sympathetic to where you're coming from, but stuck legally on what I'm trying to articulate, being the legal, lack of a term, constitutional quagmire. Is that a thing?
Oh yeah, Judge, I'm sorry. So a few points, just to conclude. One of the claims that was made is about comparing this case to others, whether or not this is now no different than any other, I guess, inmate who is under a death sentence. One of the things that really separates this case is that a warrant was in fact issued and they failed to act. They unilaterally made a decision to not act. And as the Arizona Supreme Court said, these issues of whether or not they are faithfully executing the laws, whether or not this constitutes a reprieve in violation of the governor's obligations under, I believe it's Article 5, Section 5 or 4 of the Arizona Constitution, as well as the statute that says the governor cannot grant, and in this case we contend it's a de facto reprieve, without a recommendation from the Board of Executive Clemency. What happened here is different. So then the defense had indicated that if you go through the requested relief that's in our petition for special action, that it is moot. And we're not denying that the landscape has certainly changed somewhat with the failure to extend the warrant. However, our relief under A on the last page, declaratory judgment, that's not moot.
What would I declare?
That victim rights have been violated.
What would the remedy be?
Well, part of the declaratory, and I guess maybe this ties into what Ms. Clace was talking about with the re-examination issue. I know that we are all trying to kind of interpret these decision orders that leave a lot of unanswered questions. However, the Arizona Supreme Court said that these are mixed questions of law and fact. And while this court is correct that it is the Arizona Supreme Court that must issue a warrant, they clearly were not in a position to resolve the factual issues. And when it comes to the factual issues, I'm sure that the court is already aware of the competing declarations. But for example, Director Thornell, in his declaration, said that the prior deputy director didn't record, essentially was saying he didn't record anything. Then Frank Strada, who was the former deputy director, said that for each execution, I created a folder and checklist along with a witness list that was certified by the governor's office. I stored those documents in my office, and they were at ADCRR when I left in January of 2023. He also went on to say, I also maintained emails related to each execution. Those emails were saved in a folder titled Housing Unit 9. That folder was intact and accessible. These are just examples. There is an obvious factual dispute. And that factual dispute goes to the heart of whether or not the governor has faithfully executed the laws as she is obligated to do, and whether or not the governor has exceeded her authority to grant essentially a de facto reprieve, and whether in doing so the victims have had their rights violated. And to us, those are clearly justiciable issues. Whether or not this court has the ultimate power to enjoin and actually order an execution warrant, we're not saying that, but developing and solving those facts and making factual findings will allow this to then be presented again to the Arizona Supreme Court if necessary. So I understand that the court wants us to give a list of potential remedies and then the hypothetical scenarios that would get us there. And I think what we're saying, and we believe that the Arizona Supreme Court has said it in at least so many words, that we need to have this evidentiary hearing. We need to get to the bottom of whether or not the rationale, the reason for withdrawing the warrant, the reason for not carrying out the warrant is in fact accurate. And that's the factual dispute, two competing declarations.
But we don't have hearings just to find things out so someone else can base a decision on some fact-finding decision. I mean, let's say I agree with you, it's not moot. I don't know, maybe it is, but let's say I agree it's not moot. It's justiciable, that's what I find. And then I find you're absolutely right. Everything you allege is absolutely correct, everything you just said. And the governor is just wrong. And let's say I find, and the director's wrong, and I find that they did violate victims' rights. Let's just assume all that, because I don't know that that's the case. I have no idea, but let's assume factually you're correct in all that. Where do I go from there? That's what I keep saying. At the end of the day, you're right, you went on everything, and then I'm stuck going, and it matters how, because I don't have a warrant to do anything with. It's all just a advisory kind of finding, not based on, now we're seeking a warrant, and yes, in fact, the governor is opposing and the director is opposing or not opposing, in dealing with actual justiciable controversy, for which I then could say, well, now I've got something in front of me. I think until I have another warrant in front of me that's been issued, and until I have somebody challenging what's being done in response to that, there's nothing I can do.
All right, and I appreciate, I think now that's crystallized where there's the disconnect. We absolutely believe that this court has the authority to order the governor and the Department of Corrections to take actions to prepare for an execution, to prepare as if warrants are going to be issued. That is their obligation, and here's why. For example, I know that in the pleadings, there's reference to the departmental order, the DO 710, which requires that they take immediate action on day 35, which of course the instant that that warrant is issued, the 35-day clock starts.
There's no warrant.
I'm aware, but their obligation is to be ready, because capital punishment is the law. It is the law, and the governor has the obligation to carry out the law, unless of course there is some sort of impossibility, some sort of justifiable reason. And of course, in this situation, if the contentions of the plaintiffs are true here, then it cannot possibly be a defense. This impossibility cannot be a defense when the impossibility was created by the defendants themselves, by not preparing to be ready to carry out their obligations under the law. In one moment. Yes. So, number one, with declaratory judgment, and the statute is ARS 12-1831, declaratory judgment can be issued regardless of whether there's further relief. So again, I think that that claim for relief is certainly still alive. I would also point out that if the evidentiary hearing shows that DOC is capable of either fulfilling or being ready to fulfill their obligation, we see no reason why the Attorney General's office would not request a warrant. And I would also point out that there may be a dispute about whether, when we read the statute, whether the state is only the Attorney General's office. That's for a different day. But going to your point, Judge, about what can you do, the statutes, the rules of special action, they provide this court with a number of avenues of relief. Yes, and I think I've already mentioned this, Judge, but this would be sort of the ultimate example of evading judicial review, because essentially it would set up the executive branch saying, well, we're just not going to enforce the law, and there's not going to be any warrants. Therefore, this will never be a justiciable issue, and the victims will never have their right in these types of cases to prompt and final conclusion.
Right. I'm looking at the relief requested on page 33 of the complaint.
Yes.
Paragraph C.
Yes.
Can the defendants or defense counsel address that and why that relief, which I think Mr. Green was just trying to articulate, how that might be something that does not require an execution warrant?
Is this the de facto reprieve?
Yeah,
portion of the
it's a
complaint?
special action relief prohibiting, so I guess that would be the claim for, that would be the prohibition writ? The
Yes,
prohibition
that's
writ?
correct, Your Honor, the writ of
So the
prohibition.
special action relief prohibiting the governor from granting de facto reprieve and order her to suspend any and all action commanding, that would be the mandamus part of this, any and all action commanding, authorizing, or encouraging the director and ADCRR to pause the implementation of DO 710. So now we're not talking about a writ of execution. Now we're just talking about if nobody's coming forward to carry out a sentence, a death sentence that was imposed in this case, is that something that this court could hear and decide in this matter without having a warrant of execution. Is that not just victims' rights, Article ARS or Arizona Constitution, Section Article 2.1, page 10, and then, you know, Arizona Constitution, Article 5, Section 4, and is that not something that this court couldn't decide? Because that, I don't know if that requires, maybe that's not moot, maybe that's still an issue that has to be resolved. If you have victims that say they're entitled to finality on this death sentence, and you have a governor and the Department of Corrections that disagree and take a position contrary, is that something this court can resolve?
Your Honor, the answer is no. That request for relief, just like all of the other requests for relief, depend on the existence of a valid warrant of execution. A reprieve isn't just a reprieve that is free-floating. A reprieve is a reprieve from a specific scheduled execution date. For now that the warrant is, well, there was never an execution date set to begin with, so the governor never could have granted a reprieve from an execution that was never scheduled or planned to occur. And what, as the Supreme Court held on March 22nd, the warrant of execution that was issued authorized the executive branch to proceed with the execution but didn't require it. So the governor, pursuant to that, had not set an execution date. So there's no scheduled execution for which the governor can grant a reprieve, whether lawful or unlawful. So this issue is also moot and not properly before Your Honor in light of the expiration of the warrant.
Your Honor, I would just add briefly, there seems to be a sort of blanket allegation underlying all of this that none of the officials involved are going to enforce the law, and no one has said that. The governor has not said we're not going to enforce the law. The director has not said we're not going to enforce the law. The Attorney General has not said we're not going to enforce the law. This is about specific facts and circumstances. The de facto reprieve argument was being made by Ms. Price and the Maricopa County Attorney's Office throughout this case, as Ms. Duell said, in the context of a specific execution date or a specific warrant expiration date in this case. There is not a broader command not to follow the law here that I think would be relevant in the way that's articulated here. I think what's articulated here had to do with trying to make an execution happen during the pending warrant of execution, and that ship has sailed at this point.
Do you agree with the governor's attorney that reprieve is a reprieve from the execution, from the warrant of execution, or is it a reprieve like commutation? Is it all talking about just the sentence, or is that talking about carrying out the execution? Does the reprieve just go to the writ of execution, or does it go to the sentence?
I think the reprieve goes to the carrying out of the sentence, and a warrant of execution is the mechanism by which a death sentence is carried out.
And commutation goes to the sentence or to the
I think the commutation would go to the sentence itself.
and that's the difference between, you're saying, between reprieve and commutation under the Arizona Constitution?
I believe so, Your Honor. I don't think a reprieve would change the sentence itself. It would change the timing of that sentence's execution. It's also an enforceable right. If an actual reprieve is given, it would typically have a timeline on it. It would say your sentence will not be executed, before December 31st, 2023, or something like that. This is nothing like that.
Mr. Green, do you agree with that reprieve goes not to the sentence, but the carrying out of the sentence?
I mean, I think the distinction that he's talking about as far as reprieve, a delay in the execution of the sentence, whereas a commutation is changing the sentence, that's, I think, kind of the common understanding.
Well, if that's the case and there's no writ of execution, what is there to reprieve?
Well, no, our point is that what has all the injury happened when a warrant of execution was issued, and then the governor said that she's not going to follow that, and she's not going to carry it.
But my question is, if there's no writ of execution that expires today,
yes.
what is there de facto, actual or otherwise, to reprieve? There's no writ.
1 second.
or there's no, warrant.
You're, and with the court's permission, so that you don't, we're not going back and forth whispering, is it okay if
Yes.
Ms. Wood addresses the court on that issue?
Thank you, Your Honor. The reprieve would not be dependent upon the mechanism, whether it's in place or not. The reprieve would be granting a time frame of which that sentence would not be carried out. It's not dependent on whether the warrant is actually at issue. It's just saying you are not going to have, the sentence is not going to be carried out for a certain amount of time. Whether the mechanism in place, the warrant, is in place or not, does not depend upon the reprieve. And in fact, this de facto reprieve has no timeline, whereas a legal reprieve would have a timeline. So the claim for relief that we've brought up is ripe and justiciable and is not dependent on whether the mechanism, the warrant, is actually in place or not. It's still a de facto reprieve that's been given unauthorized.
And Judge, I apologize, just one more point. I understand, again, there's always gonna be a difference of opinion about how to interpret certain things, and in this case, I believe that counsel has, his understanding is that there was not this intent or announcement to not follow the law, this general announcement to not follow the law, at least as I understood the comment. The problem is that from our standpoint, when we read, and this was Exhibit C in our petition for special action, we believe that what the governor had said was, quote, "Under my administration, an execution will not occur until the people of Arizona can have confidence that the state is not violating the law and carrying out the gravest of penalties." And of course, our factual contention is that the execution can be carried out without violating the law. But more to the point that I was making, this does sound very much like a general pronouncement that the law, this is what the law is, but I'm not going to carry out an execution, regardless of whether it's the law. And then we have this following statement. So I think this is why the Arizona Supreme Court was saying there are mixed questions of both law and fact. And the appropriate place, as I read the Arizona Supreme Court decision orders, to resolve that is here. And so again, here we are.
All right. Anything to add?
No, Your Honor, thank you.
Your Honor, may I make one final point?
You may.
Counsel keeps referring back to the Supreme Court's decision that identifies these issues as mixed questions of law and fact, and I think it's important to note and keep in mind that that came from the Supreme Court's March 22nd decision order, which was well before the warrant expired.
I'm sorry, I'm just looking at paragraph C on page 33, the relief requested. It says everything else seems to be very tied to carrying out the sentence of Mr. Gunches. It's just C that seems to be talking about de facto reprieve, but it's not focused just on Mr. Gunches. C seems to be just a basic de facto reprieve from the death penalty. Although it doesn't say that, it's just not focused on him, where all the others are. And so I guess that's as far as I can get it today. I think the only thing I could say is I could agree to having you guys do some sort of briefing on whether or not this request for relief in C is something that does not require a valid warrant of execution, and that it wouldn't be a moot issue, and it would be an issue that would be an actual controversy that I could actually order something to be done or not done that somebody has standing for. I don't know how to articulate that, but I'm doing the best I can based on what you guys are presenting me with here. And again, all I have is a complaint and petition for special action, the application for order to show cause, a couple of notices of appearances, and a notice that's not even a paragraph that attaches the Supreme Court's order that came out last night at 5 o'clock, and a response that is, and this isn't offense to anybody, I'm working on very little here, barely a page written about why it's not moot. And I will tell you, part of me says there's nothing I can do here, and there's part of me that says I should just dismiss this case now. But there's also a part of me that says this is a pretty serious matter. It involves a lot of constitutional issues, and I don't want to do that. I want to make sure if I'm going to do that, that I've given everyone a chance to be heard on it, and that I'm more fully informed on a record that isn't what I just described. So I think what I'm going to do is just allow that briefing, and then set an argument, and then see if we're any further down the road on what we've all been trying to nail down or drill down to today. I am skeptical, as I say, Mr. Green. I'm skeptical, but I don't think everything in front of me. So you're going to have to really convince me that it's not just justiciable, but it's something that's actual, that I can actually rule without making some sort of advisory, spending a whole lot of time doing a whole lot of fact finding, only to come up with something that's advisory. And who knows, by the time this briefing is done, maybe there's something else that's done that changes the whole landscape to this. I don't know. So that's as far as I can get you today.
And this probably goes without saying, Judge, I mean, we had come in prepared to ask for an expedited evidentiary hearing. I think I can see where that's going. I think the court is going to be ordering briefing and just briefing, followed by most likely oral argument on the narrow issue of whether or not the relief in paragraph C is justiciable. Is that correct?
Correct.
And what I just let the court know, I don't.
But more than justiciable, just what could I do about it if it is?
Understood.
That I'm not, yeah. I mean,
because our contention is that these, at least some of the other forms of relief, are not necessarily tied to having an active warrant in place. In our briefing, I hope it's okay with the court. We may make another run at trying to persuade you that in fact these other issues don't require that, and that those too ought to be heard by the court. I certainly understand where the court is right now, but I just wanted to make that record, Judge.
I mean, I wrote my notes say, is this special action right, justiciable, actual controversy? If so, and plaintiffs were correct in their complaint, what, if anything, can this court do about it? What remedy, if any, can it fashion? That's what I was going to order phase 1 briefing on. If the matter is right and there's something the court can fashion an appropriate remedy, then phase 2 would be some sort of further briefing or evidentiary hearing. But I think we got to do phase 1 first, which is just figure out how do I even move on this. So I'm willing to give everyone a briefing on that. I'm not going to limit it to just paragraph C. If you think it's broader, it is. I'm just telling you, I'm just skeptical of where all of this is going, just so everyone knows that. But I don't have a full enough record really for me to say for sure, that's it. It's moot based on what I have, based on what little we have, what the Supreme Court said, that's it, end of story. So we'll give everyone a chance to brief it. Look, I don't have a 25-day deadline that, maybe I could have had if the court had granted and given me 25 days to figure this out. So May 1st isn't any kind of deadline that anybody got. So you guys tell me how long you want to brief the issue that I've identified for what I'll call phase 1. I don't know if we even get to a phase 2, but for phase 1, you tell me how much time you think you need, whether you'd like to do it simultaneous or staggered, and when and if you'd like oral argument. And then I'll go from there and figure out what we're going to do. So I'll hear from the plaintiffs first.
I think we would like simultaneous. And as far as the timeline, I guess at this point, given the court's inclination, I suppose whatever the court feels is reasonable. We would like for it to be somewhat expedited, but I understand under the circumstances, it may be a couple of weeks or so.
All right, so you're proposing a couple of weeks to brief it, so you're looking at today's the 6th, so you're looking at like maybe getting your briefs in the 20th and having an argument the week of the 27th? Simultaneous briefs on the 20th-ish and some sort of argument the week of the 27th? Is what you're proposing?
let's see, you mentioned the 20th. Would it be, would it be possible if we were to make it the 18th and then oral argument on the 27th? I can make that happen. I think we can make that happen, yes.
Ms. Clace, anything to add?
No, Your Honor, thank you.
Okay, from the defense?
Your Honor, I think we would have a problem with simultaneous briefing, in part because it seems like the theories keep changing while we're sitting here in the courtroom. And I recognize this is fast-moving litigation, and what we've been doing for the last few months is briefing these things on 2- and 3-day deadlines. It's not necessary anymore, and as Your Honor notes, I think your caution here is simply because these are important issues, and I think they should be given due time to pay attention to them. So we would ask that plaintiffs file a brief first, and that we would get a chance to respond to clearly articulated arguments. You know, there's been a question about, you know, articulating what remedy could be available. They need to articulate that before we can tell Your Honor why we think that remedy is available or not available. I don't think we can guess.
Yeah, I agree with you, and I think it'd be helpful because simultaneously you'll be kind of guessing at what they're even, your words better than mine. You said it best. Mr. Green?
No, I understand. If we'll defer to the discretion of the court. I understand the idea of 2 ships passing in the night.
Yeah, that's not going to help me.
Yeah,
That's just going to
I
make it
understand.
less helpful. So, Ms. Kelly, you're standing. Did you want to add anything?
Yeah, it's Skinner, just to be clear.
Skinner, I'm sorry. I apologize.
That's okay. Mr. Gunches represents himself. He resides in the Department of Corrections. I can only visit him on Wednesdays for legal visits, although the Supreme Court has ordered some additional visits on other days. So, you know, I have a problem with expedited briefing because that does not give Mr. Gunches an opportunity to hear from me as advisory counsel and prepare his own response.
And Your Honor, I think that's a fair concern. There was a filing in the Arizona Supreme Court, I think just this past week, where it seemed like Mr. Gunches wasn't really able, except in a short meeting, to, you know, digest a motion, try to figure out a response to it. He too deserves time to digest this and be able to do his work to prepare a response. So we would ask for, you know, whenever they want to file, obviously, seems like that would be up to them. But we would ask for a few weeks after that for us to be able to respond and for Mr. Gunches as well to have that opportunity.
Mr. Gunches, did you want to add anything to what Ms. Skinner said? And Ms. Skinner, I do apologize. I have the other name in my head for reasons I won't tell you about, but it was I do apologize.
No need.
And for Mr. Skelly out there who probably knows who he is, I apologize to you, sir. So, anyway, Mr. Gunches, did you have anything you wanted to chime in other than what Ms. Skinner said for you?
Well, Your Honor, the problem was the Arizona Supreme Court was appeared to be biased against me. They wouldn't give me a time to get the briefs or to respond to the briefs. They made it impossible to respond. So this has happened like 3 or 4 times in a row. For instance, I got notification that I was supposed to file 4 hours before I was supposed to file it, and I hadn't even received the briefs. And that's been going on again and again and again. And I brought this to the attention of the court, and they're ignoring me. Now, I realize there's nothing you can do about that. It's just, and I don't see how there's anything I can do about that because they're not responding. But they made it impossible for me to respond to anything. And this all goes back to me filing my own death warrant because I want my sentence carried out.
I understand.
But the Attorney General said that it wasn't happening. And I want whatever gets my sentence carried out as fast as possible.
All right, so here's what I'm going to do. Mr. Green, Ms. Clace, you tell me when you think you can get your filing in place. Then I'll hear from Ms. Skinner about how much time she thinks her client's going to need, or Mr. Gunches is going to need to be able to get that through the Department of Corrections and be able to get something on response either through you, I don't know if he does it on his own or through you, but how long that might take, and then I'll hear from the defense on when they'd like to think that they'll be ready for a response. I will give the plaintiffs the last word, so there'll be a reply. And if you want, I'll set an oral argument. If you want to set it now, I can get that set. You can tell me how much time you think we'll need, and we'll get that set, and we'll have what I'll call phase 1 in place, and then we'll go forward and see where this takes us. And what happens between now and then, who knows? We'll deal with it as it comes. But I think that's as far as I can get this today. So, Mr. Green.
Sure, I think we've decided that April 20th would be the day for us to have it due, our initial pleading.
All right, so plaintiff's brief on the issue that I've set forth. I don't want to repeat it because I don't want to say it differently, but
Sure.
Plaintiff's brief will be due April 20th at 5 p.m. And Ms. Skinner, I'll hear from you.
I would request 3 weeks to respond. Puts us in
May
May
11th? Is that, did I do the math
yes,
right?
May 11th.
Now, is there any way that they need to get this brief to your client differently because Department of Corrections and where he's at, that changes what might otherwise get a brief somewhere much quicker?
You know, unfortunately, I think all they can do is put it in the mail and provide it to me, and then I always bring him pleadings as soon as I can.
So you'd like May 11th as response for real party and interest, Mr. Gunches. The defense?
Your Honor, assuming you want our response on the same timeline as Mr. Gunches's, 3 weeks is exactly what we were going to suggest. And I think for what it's worth, a Thursday probably makes sense, given that it sounds like Wednesdays are key dates for advisory council to meet with Mr. Gunches.
Okay. And then a reply?
Yeah, Judge, if we could maybe have just 1 week, so the 18th.
All right. All right, and then we'll set oral argument, we can set it, either June 25th or no, not June. Sorry, June 18th. June 25th or any part of date in June, maybe better.
Judge, do you have the judicial conference mixed in there?
Yes, June, that's not till the 28th of this year,
Okay.
so. I just wanna make sure I have time to,
Sure.
and I'm looking at my trial schedule and everything else that's going on here. So do you see a date that might make, how much time do you think we'll need for the argument? I know today we set it for half hour, but I also said we'll see how much more time we need. And this is a unique case, so it takes the time it deserves, so I'm trying to give it the time it deserves. So, but how much time do you think for an oral argument on these legal issues now that we've kind of narrowed them? Well.
You know, despite the fact that I even if they do remain narrowed, I think we probably ought to give ourselves maybe 2 to 2.5 hours.
We think the issues are a lot less complicated than that. I don't imagine we would need any more time than we need today, but I'll leave that to Your Honor.
So, any thoughts on that?
Agreed, Your Honor. I think an hour and a half at most.
I defer to Your Honor.
All right. So, 18th. Did you see a date for a couple hours?
Do June 23rd at 10.
June 23rd at 10?
Judge,
June 23rd at 10 a.m. to noon. You
What was
don't
that
have to
time
use
again?
all that time.
What was that time again, Judge?
June 23rd, 10 a.m. to noon.
Thank you.
I'll give you the 2 hours. That's not a, it's just in case you need the time. I always like to have more time. Some people like to give less time, but I don't like anyone to be jammed up, and more time's the better, but you don't have to use all the time. But I know it's lawyer time. I know I was a lawyer, and I know 2 hours is 2.5 hours.
Yes.
All right. Anything else from the plaintiffs?
No, Your Honor.
Anything else from the defendant?
No, Your Honor. Thank you.
Well, anything from you, Ms. Skinner?
No, Your Honor.
Mr. Gunches, anything else from you, sir?
No, sir.
All right. That's it for today. Thank you, everyone, for your time, your patience. Have a good rest of your day,
Thank you, Your Honor.
and we'll see everyone when we see you.
Excuse me, Your Honor.
Judge.
Hello?
Yes, sir.
Can I just relay a message to Ms. Skinner to have her call me or come see me as soon as possible?
She acknowledged yes.
Okay, thank you.